On August 26, 2016, the Utah Supreme Court issued its decision in the case of BOBBY NEVARES versus Adoptive Couple. Here's the link to the court's decision, and we've also included that link in the description section of this video report. BOBBY NEVARES and Mother were and remain residents of Colorado. Nevares did not become aware of the pregnancy until approximately 6 weeks before the child's birth, at which time the mother informed Nevares of her intention to place the child for adoption. Nevares then visited a Colorado-based adoption agency and indicated through it that he intended to preserve his parental rights. Mother knew of Nevares' efforts to preserve his parental rights. Mother nevertheless traveled to Utah 2 days before the child's birth without telling Nevares and gave birth to the child in Utah on September 29, 2010. The next day, she relinquished the child to a Utah-based adoption agency. After Nevares learned the child had been born in Utah, he filed a petition in a Utah district court to establish paternity and to seek custody in October 2010. The adoptive couple had, unbeknownst to Nevares, moved to Illinois and argued that Illinois, not Utah, had subject matter jurisdiction to make custody determinations concerning the child. The adoption agency placed the child with the adoptive couple in Utah on the same day that the mother relinquished her rights to the child. The adoptive couple remained in Utah for another week before they returned to Illinois with the child. The child was living in Illinois when Nevares filed his Utah paternity suit on October 18, 2010. Except for the first 8 days of his life, the child resided in Illinois. Adoptive couple filed an adoption action in Illinois on November 4, 2010, and that same day the Illinois court issued an interim custody order granting them physical custody of the child. The adoptive couple therefore moved to dismiss Mr. Nevares' complaint on the grounds that Utah was not the child's home state for the purposes of the UCCJEA, as the child was not living in Utah with a parent or person acting as a parent at the time that Nevares filed his Utah action. The district court agreed and dismissed the case for lack of subject matter jurisdiction. Here is how it all played out in the Utah Supreme Court. Under the Utah Child Custody Jurisdiction and Enforcement Act, or UCCJEA, once a state makes an initial child custody determination, it obtains exclusive continuing jurisdiction until that state relinquishes or loses that exclusive jurisdiction. Utah has never made an initial child custody determination with respect to the child. The child was born in Utah and remained here for the first 8 days of his life. During those 8 days, Utah was arguably the child's home state for UCCJEA purposes, but Utah ceased to be the child's home state once he moved to Illinois with the adoptive couple. At that point, no state met the UCCJEA's definition of the child's home state, but once the child had resided in Illinois for 6 months, Illinois became the child's home state. Utah was not the child's home state when Nevares commenced his action in Utah on October 18, 2010, because the child had moved to Illinois 12 days earlier. And even if Utah was the child's home state for the first 8 days of his life, neither a parent nor a person acting as a parent continues to live in Utah. Thus, Utah does not have jurisdiction to make an initial child custody determination. Utah also lacks jurisdiction under the UCCJEA because there is no significant connection between a child and the state of Utah. Nevares did not identify any substantial evidence available in this state concerning the child's care, protection, training, and personal relationships. Illinois has jurisdiction. Both the adoptive couple, each of whom qualifies as a person acting as a parent to the child, and the child himself have a significant connection with Illinois other than mere physical presence, as Illinois has been their domicile for more than 5 years. Because Illinois would have jurisdiction to make an initial child custody decision over the child, Utah lacks UCCJEA jurisdiction. For these reasons, the district court correctly dismissed Nevares' action for lack of subject matter jurisdiction.